Hi friend, motherhood is an important phase in every woman's life and it is a social obligation of an employer and government to protect the woman during that time. Hi friends, now let us know about Maternity Benefit Act 1961 in brief. Nature is very beautiful and it has made women to bear the child in order to keep the generation going on. Bearing child is a social obligation for a married woman and an employed woman. For an employed woman, it cannot be an exemption. So, for bearing child, it can be possible only under the supervision of an expert. So, it is our social obligation to provide provisions for the welfare of maternity women and provide her maternity benefits. Let us know about objectives of the Act. The objective of the Maternity Benefit Act 1961 is protects the employment of women during the time of maternity and entitles them to a full paid absence from the work to take care of the child. That means it should take actions to protect the employment of the woman. Many women during pregnancy they will be very worried about the employment and about taking care of child. So it is a necessary to the government and it is a social obligation for the society to make provisions to protect the employment of the women during that time. Scope and applicability of the Act. The Act is applicable to all the establishments employing 10 or more workmen. Applicability of the Act, Section 2. It applies to every establishment, being a factory, mine, or plantation, including any such establishment belonging to government, and to every establishment where persons are employed for exhibition of equestrian, acrobatic, and other performances. So that it is applicable to every establishment. And to every shop or establishment in a state in which 10 or more persons are employed or were employed on any day of preceding 12 months. So, preceding 12 months, any establishment or shop, if there are 10 or more persons, then this act is applicable to all such shops and establishments. Working women of an unorganized sector are not covered by this 1961 Act, but private sector is also covered in this Act. Section 5. Right to payment of maternity benefits. This section 5 deals with the payment. There is a right for payment of maternity benefits. Who are eligible and what is the rights for the women during maternity time. Section 5 is divided into 5 sections. So, Section 5, subsection 1. Every woman shall be entitled to and her employer shall be liable for payment of maternity benefit at the rate of the average daily wage for the period of her actual absence. So, for the period of her actual absence, so she will be eligible for salary, that is no, there is no loss of pay, paid sal, it is a paid leave. So let's go to section 5 subsection 2. No woman shall be entitled to maternity benefit unless she has actually worked in an establishment of employer for a period of not less than 80 days in the 12 months immediately preceding the date of expected delivery. So, from the expected delivery, 12 months immediately preceding the expected delivery, she should have worked not less than 80 days. Then only she will be eligible for maternity benefit. Next, subsection 3. The maximum period for which any woman shall be entitled to maternity benefit shall be 26 weeks. This increase, that means actually previously it is 12 weeks and it is an amendment in 2017 that this 12 weeks is extended to 26 weeks. This increase doesn't apply to women with 2 or more surviving children. For them 12 weeks only is applicable. So for the woman who has 2 or more surviving children, 12 weeks only applicable. For them 26 weeks is not applicable. Section 5, subsection 4. A woman legally adopts a child below the age of 3 months or commissioning mother shall be entitled to maternity benefit for a period of 12 weeks from the date child is handed over to adopting mother or commissioning mother. If any mother adopts a child below 3 months, then also she will be eligible for maternity benefit of 12 weeks. For commissioning mother also it is applicable. Section 5, subsection 5, it is amended in 2017. So, in case where the nature of work assigned to a woman is of such nature that she may work from home, the employer may allow her to do so after availing of the maternity benefit for such period and on such conditions as the employer and the woman may mutually agree. So, there are some jobs like software jobs. In such cases, we can do the work from home. So, work from home basis. So, in such cases, if the woman asks the employer to do work from home from after maternity leave also, then the employer must allow her based on the mutual agreement between employer and employee. Next, section 7, payment of maternity benefit in case of death of woman. So during delivery, if any woman is dead, then what are the maternity benefits available for them? The employer shall pay such benefit or amount to the person nominated by the woman in notice. If there is no nominee, then to her legal representative. So this, if the woman is dead during the delivery, then the employment benefit shall be paid to her nominee. If there is no nominee, then to her legal representative. Section 8, payment of medical bonus. So, along with maternity benefits, medical bonus is also given to this woman. So, every woman entitled to maternity benefit under this act shall also be entitled to receive from her employer a medical bonus of 1000 rupees. Central government may from time to time by notification in the official gazette increase the amount of bonus subject to a maximum of 20,000. So medical bonus is of 1000 rupees and central government by notification in the official gazette it can increase the amount to maximum of 20,000. Section 9, leave for miscarriage etc. So if there is any miscarriage or etc., what is the leave? How much leave she can take? In case of miscarriage or medical termination of pregnancy, a woman shall be entitled to a leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage or as the case may be. If there is any miscarriage or medical termination of the pregnancy, then the woman with along with wages, that means paid wages, she can take a leave of 6 months from the day of her miscarriage or medical termination of pregnancy. Section 9A, leave for tubectomy operation. Tubectomy operation means the operation done for restriction of kids, that means without not having any kids. So this, for this what is the leave? Woman is entitled to leave with wages at the maternity benefit for a period of 2 weeks immediately following the day of tubectomy. So in this case, in tubectomy operation, she is eligible for 2 weeks maternity leave of 2 weeks immediately from the day of tubectomy operation. Section 10, leave for illness arising out of pregnancy, delivery or premature birth of child other than miscarriage, medical termination of pregnancy. So for illness, so if any during delivery time she is subject to any illness or any premature birth of child, then the leave is leave with wages at the time of maternity benefit for a period of 1 month. In such case, if there is illness during the delivery time, then she will be paid leave of 1 month with wages along with, that means paid with leave, paid with wages, leave with wages. Next, section 11, nursing breaks. So after delivery, a woman should feed her child. So after delivery. So if she had to feed, she has to take any some nursing breaks. So in addition for rest allowed, that is leave, she will be allowed in the course of her daily work 2 breaks of the prescribed duration. No, prescribed duration, so she should not take more duration. So 2 breaks of prescribed duration for nursing the child until the child attains the age of 15 months. So up to the age of 15 months, a woman shall be eligible for 2 breaks, nursing breaks of the prescribed duration. Next, section 11A, crèche facility. This is also amendment in 2017. So every establishment having 50 or more employees shall have the facility of crèche within such distance as may be prescribed, either separately or along with common facilities, provided that each employer shall allow 4 visits a day to the crèche by women, which includes interval for rest. So, so establishment which is having 50 or more employees shall provide crèche facilities. This is amendment in 2017. Next, section 21, penalty for contravention of act by the employer. If employer doesn't provide any medical maternity benefits, or if he restricts the woman from providing maternity benefits, then he shall be liable for penalty. Employer shall be punishable with imprisonment not less than 3 months, which may be extended to 1 year, and fine not less than 1000, but which may be extended to 5000 rupees. So he shall be liable for to pay penalty and also imprisonment. So imprisonment not less than 3 months, which may extend to 1 year, and fine up to 10,000, up to 1000, which may extend to 5000. I hope you understand this act. So if this video is useful to you, please subscribe my channel. Thank you.